To this day, the government has cited no basis in law for his warrantless arrest. Yes, they have. He's not here lawfully. And his removal to El Salvador. Trump issued a proclamation. The situation changed and he's not legal. He's not here lawfully. So why don't you just take your little order and shove it, Judge? How about that? Signed, your friends. Oh, damn, son. They didn't sign it. Hearing is over. Judge Zinnis will require daily updates from the government on 3 things. Oh, gosh. The Supreme Court has spoken in the Kilmar case. The deportee who the judge ordered to be returned home got a decision, but it's not very clear exactly what we're going to get in totality because this is going back down to the lower level judge, and then she's going to have to abide by this strange decision from the court. So we're going to go through the decision itself from SCOTUS to try to interpret what's happening here because there's a lot of fake news on this saying SCOTUS came out 9-0 and ordered him to be flown back home and given a mansion. That's not what they said at all. But we also had a bunch of new filings that came in the immediate aftermath. So as soon as SCOTUS hit, Kilmar's lawyers went hog wild, started filing stuff. Trump's lawyers started filing stuff. And then we're scheduled for a hearing today. But here is what SCOTUS said after hours, late at night, in the case involving Kilmar, Armando Abrego Garcia. And we remember this person was alleged to have been a gang member and had previously missed his court dates, was already adjudicated to be non-bondable because judges found that he was not credible and a potential danger to the community. So they held him in custody. He then, of course, appealed that and lost. So he's had plenty of due process. He's not in the country legally. He doesn't have a visa, not a permanent resident, only was not supposed to be removed to El Salvador. That's where he got removed to, but he's presumably still there. So what the Supreme Court said is this. On March 14th, the United States removed Kilmar, an alleged gang member, from the United States. He's currently held in El Salvador at SCOTUS. Now, the United States acknowledges that he was subject to a withholding order forbidding his removal to El Salvador, only that, and that the removal to El Salvador was therefore illegal. Now, the United States represents that the removal was just an administrative error. The United States alleges, however, that Abrego has been found to be a member of a gang called MS-13, a designated foreign terrorist organization, and that his return to the U.S. would pose a threat to the public. Now, Abrego says, I'm not a member of MS-13, and that he's lived safely in the U.S. with his family for a decade and has never been charged with a crime, which might be true. Never been charged with a crime, but by virtue of entering the country illegally without registering, that's a crime. Now, on Friday, April 4th, the United States District Court for the District of Maryland, Judge Zinnis, that's the judge who was ruling on the order to direct the government through Trump to facilitate and effectuate the return of Abrego. And remember, she said he needs to be back here by midnight, 11:59 p.m. on Monday, April 7th, or else. Now, on the morning of April 7th, the United States filed this application to the Supreme Court saying, we can't get this guy back by Monday at midnight. It's not going to happen. Chief Justice John Roberts issued an administrative stay, and then the full court heard the application. Now, the application is granted in part and denied in part, subject to the direction of this order, writing from the Supreme Court saying, due to the administrative stay issued by Chief Justice John Roberts, which we read through earlier this week, to that extent, the government's deadline has now passed. So to that extent, the government's emergency application is effectively granted, right? The deadline is no longer effective, so they won that. But the rest of the district court's order remains in effect, but it requires clarification on remand because the judge's order is terrible. And this is the court asking, or basically giving the lower level judge an opportunity to save face, saying your order was very bad and you can fix this if you'd like, but we need you to do that. Saying the order properly requires the government to facilitate the release from El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador, right? So what does that mean specifically? The intended scope of the term effectuate, though, so the judge said facilitate, but effectuate is different. That, however, is unclear and may exceed the district court's authority. Now, the district court should clarify its directive with due regard for the deference owed to the executive branch in the conduct of foreign affairs. And so for its part, the government should be prepared to share what it can concerning the steps it has taken and the prospect of further steps. So very wishy-washy, saying the order heretofore entered by the Chief Justice is vacated. It is vacated. So what we have to do is send this back down to the court, and the district judge will have to figure out what to do about it. Saying, here's the statement of the dissenting judges, saying the United States government arrested Kilmar Armando Abrego, says the dissent, and flew him to terrorism confinement center. This is the dissent, saying to this day, the government has cited no basis in law for his warrantless arrest. Yes, they have. He's not here lawfully. And his removal to El Salvador. Trump issued a proclamation. The situation changed and he's not legal. He's not here lawfully. They say say the government remains bound by an immigration judge's order expressly prohibiting the removal to El Salvador because he faced a clear probability of the future prosecution there. Instead of hastening to correct its egregious error, the government dismissed it as an oversight. The government now requests an order from this court permitting it to leave Abrego, a husband and father with no criminal record, in a Salvadorian prison. The only argument the government offers in support of its request that the United States cannot grant a relief once a deportee crosses the border is just plain wrong. And so the dissent goes on. And of course, we now have questions about what to do. Let's take a look at what happened now. Immediately after the Supreme Court came back down with their decision and they sent this back down and they said, please clarify what you mean. What does facilitate mean? What does effectuate mean? Soon as that happened, Abrego's lawyers sent this into the court. They said, we write on behalf of Abrego. The Supreme Court today ruled that they must facilitate and effectuate the return, and that remains in effect, but that the term effectuate may require some clarification. Now, given the grave danger to Abrego's Garcia's life, we request the court bring him back immediately to address the government's compliance and to address the compliance with this court order, saying, bring this person back. All right, so Jonathan Cooper, writing for gangbangers like Abrego, are demanding that he be returned. So in addition to that, we got now a new order from the judge. So Judge Zinnes came out. Soon as the Supreme Court sent this back down to her court, she came out and wrote the following. So a lot of stuff happened last night back to back. This is the judge writing, Judge Zinnes, saying the Supreme Court's decision in Nome versus Abrego Garcia affirmed this court's order and directed that on remand, this court clarify its use of the term effectuate. What does effectuate mean? According proper deference to the executive branch in its conduct of its foreign affairs. So the judge says, so to this end, the court hereby amends the order to direct that defendants take all available steps to facilitate the return of Abrego as soon as possible. Okay, we direct you now to take all available steps to facilitate, which doesn't mean that you are ordered to effectuate. It's just to facilitate. So in other words, the judge can't force them to do anything. It can just encourage them to facilitate it. Now, as the Supreme Court made clear, said the judge, the government should also be prepared to share with what comes next and your further next steps. And so accordingly, the court directs Trump to file by no later than 9:30 a.m. today. This is already expired, by the way. A supplemental declaration from an individual with personal knowledge addressing the following: the current physical location and custody status of Abrego, what steps, if any, Trump has taken to facilitate his immediate return, what additional steps Trump will take to facilitate his return, and the extent the defendants believe any portion of their submission must be filed under seal, follow the rules. Now, we also will have a hearing today, 1:00 p.m., which we're waiting to kick off, signed by Paula Zinnes. Okay, so judges came back down, said, what does effectuate mean? The judge basically deleted effectuate, just said take all available steps to facilitate the return, is what she wrote. And she said to the United States as soon as possible. Now, I don't think the Supreme Court necessarily said that. Now, she said that, right? She posted to the extent that they believe they can file under seal, file under seal. Otherwise, get this dude back to America. So then Trump responded. Now, Trump sent this one right this morning, right before the hearing. Said, Trump now requests that the court modify its amended injunction. Please give us a modification so we can have a reasonable period of time to review this stuff. The Supreme Court entered its order partially granting and partially denying the stay after business hours last night, saying the initial deadline contained in this injunction, which requires Trump to provide the court with a plan for a diplomatic engagement 30 minutes into the business day after the Supreme Court ruled on this, is ridiculous. It's inconsistent. The Supreme Court gave them a clear instruction to clarify your directive. Hey, court, you are supposed to have due regard for the deference owed to the executive branch. Due regard. Now, that deference requires that the executive be giving a meaningful opportunity to review the Supreme Court's decision before it is ordered to report what steps it will take in response to that decision. It would also be impracticable for Trump to comply with the court's deadline only a few hours after the Supreme Court issued an order. Like, we can't do it. So the amended injunction further is inconsistent with their directives to be in compliance with the deadline in the challenged order is no longer effective. Okay, so you need to give us more time. So Trump DOJ asked for this, says, please modify your order until 5 p.m. on Tuesday, April 15, 2025. So that's like 4 days from now. And to reschedule any hearings on the matter until Wednesday, April 16th. Now, the judge didn't bite that at all. Okay, so they want until next week on Tuesday. The judge came out and said, how about no? How about you get until 11:30 today? They say the defendants asked this court to extend the deadline to respond to its order, arguing that Trump needs several days to meaningfully review the decision that was issued at 7 p.m. last night. It is impracticable for defendants to comply with this order. They say this supports an extension, but the judge says no. First, the act of sending Abrego was wholly illegal from the moment it happened, and you've You've known about it from the beginning. Now, as the Supreme Court says, it was therefore illegal. They even acknowledge you did this illegally. Now, second, Trump's suggestion that they need time to meaningfully review a 4-page order that reaffirms this basic principle blinks at reality. Okay, can you explain that? And third, Trump misconstrues the Supreme Court's order, stating that the original deadline is no longer effective, as somehow suggesting that the court's amended order requiring prompt attention to this matter is inconsistent. Nothing could be further from the truth. Now, as the Supreme Court plainly stated, the government should be prepared to share what it can concerning the steps it has taken and the prospects of further steps, all against the backdrop of this court's needing to ensure the government lives up to its obligations to follow the law. And so accordingly, the court grants in part the request and will extend the filing deadline until 11:30 a.m. today. Amazing. Thanks for all that additional time, Judge. Now, the hearing date and the time will remain unchanged, signed by Paula Zinnes, Obama judge. So gave them basically no time at all to respond. Trump responded to a new amended order. Okay, so the judge just issued that new order and said you have to respond by 11:30 and you got to be here for the hearing. Trump just said this. Sorry, Judge, we asked for more time. We are unable to provide the information requested by the court on the impracticable deadline set by the court hours after the Supreme Court issued its order. So you're not getting it. The Supreme Court's order directs the court to clarify its directive with due regard for the deference owed to us. You're not owing us any deference. This court has not yet clarified what it even means to facilitate or to effectuate the return as it relates to this case. The plaintiff is in the custody of a foreign sovereign. He's their citizen, not ours. Trump requests and requires the opportunity to brief that issue prior to being subject to any compliance deadlines. So we need more than your little order. Needless to say, Trump was under no obligation to take action under this court's order while it was administratively stayed. So you don't get to say that we should have been working this whole time to do this, that, or whatever. It was stayed. That's what being stayed means. In light of the insufficient amount of time afforded to review the Supreme Court's order following the dissolution of the stay, Trump is not in a position where they can share any information that's requested at all. That is the reality. You're not getting it. Trump received the order late in the evening last night. We're reviewing the order. We're actively evaluating the next steps. It is unreasonable and impracticable for defendants to reveal potential steps before those steps are reviewed, agreed upon, and vetted. Foreign affairs cannot operate on judicial timelines, in part because it involves sensitive country-specific considerations that are wholly inappropriate for judicial review. So why don't you just take your little order and shove it, Judge? How about that? Signed, your friends. Oh, damn, son, they didn't sign it. That's great. Okay, so Yakov, Drew, Ernesto, and Tara DeShields. Shout out to you guys for being here and sending that one in. Just say, we're not even going to sign it, Judge. So you can come after all of us, right? No one's taking ownership of it, but they're all going to kind of join together and not sign it. It's like not going to sign that one. So enjoy it. You're not getting the files today, Judge. Sorry. Thanks for playing, though. So Kyle Cheney said this. Update. We've arrived at 11:30 with no responsive filing from the DOJ yet. Hearing set for 1. DOJ says it's not going to comply. Not happening. We just read it. Says the DOJ position says, well, I want information, not just the ones. So Judge Zinnes takes the bench. All rise. Oh, gosh. Says Zinnes begins by summing up the SCOTUS order, which she notes affirmed all aspects of my decisions and all my prior orders, and say for requiring clarification. So saying this court amended its prior order and made clear what the government must do with the Supreme Court's directive. Hearing is over. Judge Zinnes will require daily updates from the government on 3 things. Oh, gosh. What is his location and status? What efforts has it previously undertaken to get him back while her order was in effect? What efforts it may take going forward? Got it. Yeah, what efforts? So she's going to try to hold him in contempt too. She's micromanaging the executive branch. That was a quick hearing. Yeah, this is a good comment here from Nick. She can't do anything, such a joke. Zinnes is now asking for an update on Abrego Garcia's current physical location and his custodial status. Where is he? What's going on? DOJ Drew Ensign says, Your Honor, well, we're still internally reviewing the Supreme Court's decision and we're vetting what we can even say to this court. Judge says, what? What do you mean? What can you say to me? This is a very direct question. Government says, well, Your Honor, yeah, maybe to you, but I don't even know where Abrego Garcia is. I haven't been told that, so I can't answer because I don't know. It's national security. It's not my business. I'm just a lawyer. Zinnes is probably fuming mad. I can't believe this. We're here for a trial in my courtroom. I got out of bed on a Friday, dragged everybody in here. There's a man who's probably went nuts. Says this is basic information. I already ordered it to be provided, and you have to give it to me. And blah blah blah. Shout out to Drew. I don't have that information provided to me, Judge. Guess I'll just sit here. So then Zinnes is losing her bananas. Says Zinnes is now demanding details on what the administration has done to facilitate his release. What have you done? Did you try to do this? Well, I issued the order before the Supreme Court issued a stay. Did you guys start to remove him? Who's in charge? How'd the chain of command go? Blah, 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 all the things. Your Honor, the defendants are not yet prepared to share that information. Shouldn't have had a hearing right now. You're upset we don't have the information. You shouldn't have had a hearing. Oh, so that means that they've done nothing is what you're saying. Because if you're not giving me details, then I guess guess that means they've done nothing, and I'll just presume that. And I want a yes or no answer from you right now to whether the administration has done anything whatsoever to facilitate Abrego Garcia's release or return. Have they done anything at all? Drew says, Your Honor, I don't have any knowledge of that. I'm not familiar with the actions of what's happened. I'm not familiar. Well, you do understand that you're sitting here in my courtroom, and the Supreme Court said that you should be prepared to provide info to me, but you haven't. And they've spoken quite clearly, and yet I can't get an answer out of you. Ensign says, well, Your Honor, the government, we can't prepare and file something. We told you that on Tuesday, but we're going to assert privilege and we're going to assert, protections over our information. That's why we need time. And that's the deference that you owe us at the executive branch. Ensign says the government can be prepared to file something by Tuesday. Zinnis says, Tuesday? We're not going to slow walk this, says the judge. We're not relitigating what the Supreme Court has already put to bed. And they said, well, Your Honor, we read the Supreme Court's order differently. Lawyers for Abrego Garcia now jump up. Your Honor, this is ridiculous. These Trump lawyers are playing games with you, depriving the DOJ of information. The court has ordered it from Trump. You have to give it to them and they have to give it to you. So you should demand testimony from all of the officials in the know. You should haul them in here and see what they know. Well, I might do that. But I think what I might do is a very quick briefing order. Yeah, because this judge is pathetic. She can't do anything. Very quick briefing order. Even the Supreme Court's trying to judge, calm down. What does facilitate mean? What does effectuate mean? Show them the deference that is owed. Because if you try to force them to do something, they just say no. A very quick briefing order. And they've got justification from it and cover from the Supreme Court. They're owed a deference. Now, Zinnis says she will demand daily updates from the government. We're going to make a record of what, if anything, the government is doing, is not doing. And I'm going to rule as quickly as I can. So the hearing is over. Very short one. Kyle Cheney reported it. Want his location and status, efforts that have been previously undertaken, and what efforts it may take going forward. So, of course, we will see what happens next, but that's the hearing. And so the Supreme Court issued a ruling, but is Trump going to bring back Abrego Garcia back to the United States of America? Do you think that's going to happen? Think he's going to put him on an airplane and send him back to America? I don't think so. So this judge is trying to create a contempt trap. So far, the Supreme Court has not wanted to jump in here and settle this. They could do that, but they're not. So as it stands, we might just be in this long game of updates and privilege and a battle back and forth. Whatever happens, we'll be here continuing to cover it. But we'll hope Trump and Kristi Noem and the DOJ continue their efforts to protect our country and afuera the terrorists.